The sacred law. Although the Ottoman sultans were the sponsors of Islamic law 5, the Sharia, they were not its originators. Islamic law was not the creation of a Muslim state or sovereign, but rather the creation and common property of the Muslim community, regardless of political divisions. Its origins lay in the 8th century in the discussions of jurists who formalized its basic concepts and terminology. By the 10th and 11th centuries, it had achieved a classical elegance in its literary forms and subtlety and sophistication in its conceptual apparatus. At the same time, the jurists had developed a theory of the origins of the law which gave it an unquestionable legitimacy. They located its source directly in divine revelation. God had made known His eternal word to mankind in the Quran, which He had revealed through the Prophet Muhammad. The Quran was therefore the first source of the law. The second was the record of the sayings and actions of the Prophet, whom God had chosen as an exemplar to mankind. The Quran is indeed the source for some statutes, such as the rule which allows a man to marry up to 4 wives, and the basis for some areas of the law, notably the rules for inheritance. The direct influence of the Quran is, however, limited. The traditions of the Prophet were a more abundant source of legal authority. These probably in fact emerged in parallel with the law itself, and served to justify newly formulated doctrines by projecting them back to the time of the Prophet 6. But, whatever their origins, the study of traditions became an important element in Islamic legal science. To supplement these divine sources, the jurists also recognized legal analogy, the unanimity of juristic opinion and custom as supplementary bases of the law. The belief in the divine origins of the law gave it a prestige which raised it above the political authority of the moment. It was the ruler who brought the law to life by putting its ordinances into effect, but no ruler could alter its substance. The interpretation and transmission of the law always remained in the hands of scholars, the ulama, who, by virtue of their role as guardians of the tradition, always enjoyed a position of power in Islamic societies. Islamic law was not, however, monolithic. There was a distinction between the law of the Sunnis and the law of the Shiites, and Sunni law itself, early in its history, divided into 4 schools. These were the Hanafi, Shafi'i, Maliki and Hanbali schools, each named after its supposed founder. The differences between the doctrines of the schools were not great, but, once established, each school became virtually impervious to the influences of the others. Loyalty to a school became a characteristic of Islamic jurists, much of whose originality went into defending school doctrine. Here, for example, the Hanafi jurist Mardignani, d. 1198, is defending the Hanafi view that a gift becomes the property of the donee only after he or she has taken possession. He is refuting the Maliki opinion that offer and acceptance are alone enough to transfer ownership. In the opinion of Malik, the donee's ownership of the property is established before he takes possession, by analogy with sale. But we, Hanafis, follow the words of the Prophet, peace and blessings be upon him. Gift is not permissible before the gifted object has been taken into possession. The intention of this is to deny that ownership is transferred, because the mere permissibility of gift is established without taking possession. The Hanafis also stipulate taking possession, because making a gift is a voluntary act, and to establish ownership before the donee takes possession would make incumbent on a voluntary agent something for which he has not volunteered, namely delivery of the gift. School tradition became a distinguishing mark of Hanafi jurisprudence, and this also had an effect on the practice of law. Only in 2 cases, for example, do Hanafi jurists permit adherents of their school to have recourse to a non-Hanafi judge for the solution of problems. Hanafi law does not permit a woman whose husband has deserted her with no maintenance to seek a termination of her marriage, nor does it permit the dissolution of an oath. In these 2 cases, however, Hanafi jurists allow Hanafis to seek a termination of the marriage or dissolution of an oath from a Shafi'i judge, since both these things are possible in the Shafi'i school. This, however, is a rare exception to the exclusivity of each school's doctrine and practice. Contrary, perhaps, to expectations, the nearly impenetrable borders between the schools of law did not lead to excessive rigidity in legal thought or practice, since, within itself, each school accommodates differences of opinion. Despite the theory of divine revelation as the source of law, the method which jurists normally in fact use to legitimize a doctrine is to attribute it to an earlier jurist of the school. The Hanafis typically attach legal opinions to the name of the school's founder, Abu Hanifa, d. 750, or to the names of his 2 disciples, Abu Yusuf, d. 798, and al-Shaybani, d. 805. In Hanafi literature, it is common to find opposing opinions attributed to these figures, with each view representing a legitimate doctrine within the school. On the question, for example, of whether it is permissible for two non-Muslims to witness a marriage between a Muslim man and a non-Muslim woman, the jurist Quduri, d. 1037, writes, according to Abu Hanifa and Abu Yusuf, it is permissible, but Muhammad al-Shaybani said that it is not permissible. On the question of whether the owner of a house or its current occupant pays blood money when a corpse is found on the premises and the killer is unknown, Abu Hanifa and al-Shaybani make the owner liable. Abu Yusuf, on the other hand, fixes liability on the current occupant. In both these cases, either doctrine is valid, and judges could choose which one to follow in a particular case. For each problem, therefore, unless it involved a fundamental doctrine, a school might offer two or more solutions, allowing for flexibility both in juristic debate and in legal practice. In its contents, Islamic law covers all aspects of Islamic life. Any comprehensive legal text begins with the acts of worship, the ritual acts which mankind, as his slaves, owe to God. These are the laws, which every Muslim must know at least in their fundamentals and which, in many ways, define Muslim life. Prayer, for example, is obligatory, and if the prayer is to be valid, the worshipper must be ritually pure. To achieve this state requires him to make a ritual ablution after most forms of bodily emission and even after sleep, with the consequence that mere physical existence serves as a constant reminder of God's command. The requirement to pray 5 times a day at set hours, to attend the communal prayer on Friday and to fast annually in Ramadan not only reminds Muslims of their obligations to God, but also defines their sense of the passing of time and, through the congregational prayer and universal fasting, create a sense of a religious community. The Friday prayer also had a political aspect. The law requires the prayer leader to be either the Muslim ruler himself, or the ruler's appointee, and hence it was through the obligatory congregational prayer that Muslim sovereigns broadcast their authority and the congregation signaled their obedience. The longer section of a comprehensive manual of Islamic law regulates transactions between persons. It is here that the jurists discuss, for example, marriage, maintenance, divorce and inheritance, or, in the fields of commerce and property rights, sale, preemption, hire, pledge and gift. In this section, too, the jurists lay down the rules for the foundation and maintenance of trusts, rules of evidence and procedure in court, and other matters important to the everyday life of the community. However, although this section of the law deals predominantly with secular affairs, ritual and religious considerations are always present. In the first section of his chapter on invalid sale, for example, Quduri reminds the reader that sale is invalid when one or both of the objects exchanged is ritually forbidden, such as the sale of carrion, blood, wine or pork, these being items which are forbidden to Muslims and so of no commercial value. Furthermore, the jurists included in the same section as covers the secular affairs of Muslims, chapters which relate more closely to an individual's relationship with God. Examples are the chapters on oaths, ritual slaughter, and religious taboos in hunting. In brief then, Islamic law is a religious law, and it is adherence to it that shapes and defines an Islamic society. A further characteristic of Islamic law is its tendency to devote energy and space to discussions of cases which have no application. In reality, jurists frequently take a practical rule of law and then discuss its hypothetical ramifications in ever more minute detail. This concern with details which often have little or no bearing on reality is an important element in Islamic jurisprudence. Law, in fact, was seen only in part as offering a practical legal system. Taken as a whole, it represents God's will, or at least man's effort to discover God's will. It is therefore an act of piety to examine every tiny aspect of a legal rule, however remote from the real world, because it is by doing so that man comes to know God's infinity. There has never been an expectation that mankind can, in practice, conform to the law in every detail. This remains a pious aspiration, but never a present reality. Another characteristic of the law is its conservatism, and, in places, even its archaism. This is most plainly visible in passages where the jurists retain from earlier texts rules which had no application in their own times, or words whose meanings they probably no longer understood. For example, when discussing the fixed sum compensation due for unintentional killing and injury, legal texts up to the 19th century persist in expressing the sum due in terms of different categories of camel, using the same technical vocabulary for camels as the founders of the school had used in the 8th and 9th centuries. Archaism was not necessarily a barrier to the application of the law. In the case of compensation for death and injury, for example, it was possible to convert the tariff expressed in camels to a monetary or other value, so that the rules became applicable in practice. Nonetheless, the law remained conservative. Jurists continued to transmit the material, and indeed exact phrases and passages of text, which they had inherited from their predecessors. Especially, they continued to work within the framework of concepts which the founders of the schools had established between the 8th and 11th centuries. This does not mean, however, that innovation was impossible. In commentaries, in particular, by discussing hypothetical cases relating to a legal rule, jurists could develop sub-rules in almost infinite variety. Furthermore, manipulation of existing concepts could create new legal discussions and solutions. On the question of land and taxation, for example, the jurists treat land as a commodity in private ownership, whose tax status is dependent on what happened to the land at the time of the Islamic conquest. If it remained in the ownership of infidels, the land paid, and continued to pay, even if subsequently sold to a Muslim, a higher rate of tax than land whose ownership passed to one of the Islamic conquerors. This was a juristic fiction. In reality, much of the land in the medieval Islamic world was held by feudal tenure, whereby a ruler allocated the occupancy of the land to a soldier or tax farmer in return for military or fiscal service. Muslim jurists took note of this reality and attempted to describe feudal tenure. Nonetheless, they did so in terms borrowed from the classical laws of land and taxation, 8 which they continued to expound and discuss in detail. From the 16th century, Ottoman jurists, too, attempted to explain the Timar system within the framework of classical legal theory, the laws of homicide present. Another example of how jurists could manipulate existing rules to create a new solution. In cases of indirect killing, where A orders B to kill C, the law fixes liability on the contract killer, B unless a physically compelled B to carry out the act, he is not liable. In practice, however, a judge might consider A's intent to kill and is ordering B to do so, as culpable. Following the classical theory, he should fix liability on B, the actual killer. However, the law also allows judges or other authorities to impose punishments at their discretion, usually remaining vague as to the offenses to which this applies, and to the level of punishment. The judge could therefore invoke this power and impose a discretionary punishment on the indirect killer, A. In this way, he could, by combining two available rules, satisfy the demands of justice without upsetting the conceptual structure of the law. This was, however, practical manipulation of the law, rather than a conceptual development. Despite its conservatism, therefore, Islamic law did provide the materials for a workable and fairly flexible legal system. However, in 3 areas in particular, it had a very limited application in practice. These were land tenure, taxation 9 and criminal law. 10. In the case of land tenure and taxation, the jurists did find ways of describing what was happening in practice, but what they were doing was to create legal fictions to describe an existing situation which they had not created and did not regulate. An Islamic notion of criminal law, however, scarcely exists. Islamic law treats homicide and injury to the person as, in Western terms, civil offenses. It is the injured persons or relatives of the deceased, rather than the government authorities, who bring the claim against the accused. Only for 5 offenses: fornication, false accusation of fornication, wine drinking, theft and highway robbery, does the law make the authorities responsible for prosecuting the case and demanding the fixed punishment. At the same time, however, it imposes so many procedural obstacles to successful conviction that the penalties for these offenses remain symbolic rather than real. A prosecution for fornication which, if successful, would require stoning to death or flogging, requires 4 male eyewitnesses to the act. A conviction for theft, which would entail the amputation of a limb, can be averted if the accused states simply that he thought that he was the owner of the stolen goods. The effect of these punishments is therefore rhetorical. They symbolize the enormity of the offense in the eyes of God, but are not real penalties for application in this world. In addition to these fixed punishments, the jurists recognize the right of the authorities to inflict penalties at their discretion, but never systematize the rules. The result was to pass responsibility for penal law to the secular government. In practice, therefore, Islamic law has regulated religious rituals and most areas of secular life. However, in the fields of land tenure, taxation, and criminal law, it is secular law that has dominated. This was as true for the Ottoman Empire as for other parts of the Islamic world. The preservation, transmission and application of a body of law requires permanent institutions and offices. The origins of Islamic law lay perhaps in the debates among groups which gathered informally around scholars of distinction. From the 11th century, however, the typical institution of Islamic learning was the college, attached to a mosque and supported by a trust. From its 11th century origins in Iran and Iraq, the college became a characteristic institution throughout the entire Islamic world. 11 It was here that the professors taught the law and other Islamic sciences, and where some of them composed the manuals of law which preserved the tradition and served as textbooks for students. In the hierarchy of esteem, it was the writing jurist whose books present the law in its purest form that enjoyed the most revered position. The colleges preserved and taught the law, but it was not they who put it into effect. This was the duty of muftis and judges. The mufti was a jurisconsult who offered authoritative opinions, fatwas 12, on all questions of law which anyone, from the monarch to his humblest subject, might ask. In many parts of the Islamic world, he achieved his position informally through reputation for learning. Although in the Ottoman Empire after the 15th century muftis were usually official appointees, it was the mufti who acted as mediator between the divine law and the affairs of mankind, and in this capacity occupied the next rung of esteem, below the writing jurist. Like the writing jurist, he had no executive powers. A fatwa is an opinion, not an edict, and to put it into effect requires its enactment by a judge or governor. The judge, or qadi, on the other hand had executive power. In theory, at least, the mufti owed his position to his knowledge of God's law, and was in principle superior even to the monarch, a concept which Ottoman ceremonial preserved by making the sultan stand in the presence of the chief mufti. The judge, on the other hand, was a royal appointee to whom the ruler had delegated authority, and it was by virtue of this delegation of power that his judgments in court were binding. They were not, however, valid as precedents. A judge's decree was effective only in the case to which it applied. An authoritative legal text or fatwa, on the other hand, was universally valid. It was the figures of the writing jurist, the teacher, the mufti and the judge who preserved Islamic law and put it into effect in the Ottoman Empire, as they did throughout the Islamic world.